Hey everyone, it's Mark, and a few weeks ago I covered this video on the channel. Well, I found another video of this same exact sovereign citizen, and he's in court, and of course he's arguing jurisdiction. Let's roll the audio.
So this is docket number 1973-6-19. You are Carl DeVoyd, sir.
I'm the living person, Carl DeVoyd. Sir, may I please report? I want to let the court know that I'm here under special appearance and not general or voluntary, but under threats of arrest and their consequences if he fails to do so. If we move forward, sir, because I don't understand the nature and cause of the charge.
I've said this in past videos, but if you don't understand what you're being charged with, then you should hire a lawyer. Don't try and defend yourself.
I'm not even sure what jurisdiction the court is operating under right now because the state has failed to disclose what jurisdiction we're operating under. And if there's not a jurisdiction, then I'm going to move for the dismiss for lack of jurisdiction over this person.
So you've been charged with false pretenses and also uttering a forged instrument. There is what we call an information, which is a charge.
I'm going to object right now before we go any further, Your Honor. Can we establish legal intent for jurisdiction in this courtroom for the record?
Well,
because jurisdiction, depending on the jurisdiction, criminal law applies differently to criminal civil common law or criminal admiralty maritime law. So I have to know, and I have the right under the due process of the Sixth Amendment to know the jurisdiction that I'm being charged under. And how can I proceed and handle my legal affairs if I do not know the jurisdiction that the court is operating under?
Let me answer your question, okay? I have reviewed what's called the information in the affidavit. That's the charge and the sworn statement by the officer. The allegations there suggest that this happened in Vermont, and I don't want you to respond one way or the other as to whether or not you agree or disagree with them. So to answer your question, Vermont does have jurisdiction, this court does have jurisdiction to go forward, and I found probable cause.
Okay, can you state the jurisdiction for the court, what jurisdiction we're under?
Yeah, the state of Vermont.
Well, state of Vermont statutes are not jurisdiction, so I'm going to object for appeal process issue.
Okay, your objection is noted. So today's purpose is simply to determine whether or not you're entering a not guilty plea. You were asked whether or not you wish to proceed without an attorney, and I see that you didn't sign the waiver form. So the first question is, do you wish to proceed today, which is what it's just an arraignment, to proceed without an attorney? Or do you want to speak to a public defender who will, if they're not here yet, will be here later this morning?
I have a right to handle my own legal affairs in the corporation of court here, and I'm still going to object because this court has not stated jurisdiction, if it's either criminal common law jurisdiction or admiralty under Article 1, Section 8, Clause 17 of jurisdiction. It's either criminal common law or criminal admiralty, and I need to know so I can prepare an adequate presentation for my legal defense and handle my legal affairs in the right manner, in the right direction. But I cannot do that if the court refuses to state what your statute is not jurisdiction. Your state statute, excuse me, I'm nervous. I'm fighting for my life for something I didn't do.
One way the judge can prove that the state has jurisdiction is to hold them in contempt of court.
Vermont statutes are not jurisdiction. Jurisdiction is either criminal common law or criminal admiralty. And I have the right under the Sixth Amendment of the Constitution of the United States to know the nature and charge and understand what jurisdiction I'm being charged in. The state is not a jurisdiction. I am the state.
So, Mr. Boyd, you can proceed right now if you wish, and I'm not going to get into your arguments any further. I do have some concerns based on what you're expressing as to whether or not you understand fully this proceeding. I would like to have you speak to the public defender this morning if you're willing to do that, and then come back.
For the record, Your Honor, the law provides that once state or federal jurisdiction has been challenged, it must be proven. That's under Maine versus T-Volt, I think it is 225/02/1980. Jurisdiction can be challenged at any time, and once challenged cannot be assumed, it must be decided. Bassel versus Utah Power and Lights Company, 495 F2D, 906 and 810. There is as well no discretion to ignore the lack of jurisdiction, and that's what this court is doing, so I'm going to object to that.
I understand your
The
objection.
burden of shift, the burden shifts to the court to prove jurisdiction. The court hasn't stated jurisdiction. They're trying to fabricate a statute as a jurisdiction. And it's,
Mr. Boyd, I'm gonna give you a response, and then we're gonna proceed.
Okay.
Your objections are noted. There are two forms of jurisdiction, personal and subject matter. You're here, you've been served, and you're in Vermont, we have personal jurisdiction. This is a criminal court in the state of Vermont. This court has subject matter jurisdiction over this proceeding. I've found probable cause, so I'm not gonna entertain your arguments any further.
okay, I'm just going to object to personal
I understand,
jurisdiction
and you certainly have a right.
for the record.
I understand, and you certainly have a right at a later point to raise these issues if you think this court does not.
Well, I can't enter a plea then, null plea, without knowing the proper jurisdiction, because personal jurisdiction.
And what I'm gonna do is I'm gonna postpone this morning, and I want you to speak to a public defender.
No, Fred versus California can't force a lawyer upon me, Your Honor.
The judge is trying to help him by letting him speak to a public defender, but this sovereign citizen is so stubborn and arrogant because he thinks he knows the law better than everyone else, so of course he doesn't want to speak to a public defender.
That's
If we're gonna move forward, then I'm not gonna waive my 24-hour rule, and I'm gonna request a 5-month rule for.
And what I'm gonna do is I'm gonna enter not guilty pleas.
I object, Your Honor. You're practicing law from the bench, and you're forbidden from doing that.
The judge is allowed to enter a not guilty plea on a defendant's behalf if the defendant isn't willing or isn't able to enter a plea themselves.
So for the record, I object.
And your objection.
Unless you're making a legal determination that I'm actually not guilty.
I'm entering not guilty pleas on counts 1 and 2, and I'm gonna release you on the following conditions. You have
Can
to
I
come
be
to the
appeased
court.
about the affidavit, Your Honor? And I'm sorry I interrupted, but there's so many holes in it. We've got to be determined.
This is not an opportunity, today,
Well, there's not an arraignable issue. And I have a right to challenge that and be heard as due process. I'm saying that there's not an arraignable issue right here, that this is fabricated. There's no statements that the state said that there is.
I'm asking you not to interrupt me and let me complete, okay? I understand that you object and your objections are noted, okay? This is that we're gonna release you subject to conditions, you have to come to the court when you're required to do so. You have to give your attorney, if you end up with one, or the court clerk, your address and phone number, and any changes to let the court know that. This is important, you must not have contact with Elsie Ducharme, and that's in any form. You're gonna be given this in writing and sign, and requested to sign it, okay? And you're also required to return to court, and do we have a date?
I don't waive my 24-hour rule, Your Honor, for the record, and I move for a probable cause hearing within 24 hours under Rule 5.
You do have that right, so if you want, you can come back here tomorrow
Yes.
for the arraignment.
Yeah, because I don't believe you guys have probable cause over, or jurisdiction over this person.
All right.
Can you state for the record what probable cause you're establishing that this affidavit or this complaint has?
The affidavit, you've seen it and read it, and you've acknowledged.
Well, I don't understand it.
That's why the judge wants you to talk to a lawyer, so that the lawyer can explain it so that you will understand it.
If you want to come back tomorrow, you have the right to do that. So we'll give you a notice. If that's what you wish to do, you can invoke the 24-hour rule and come back tomorrow to do this.
Well, can I understand the nature of what the probable cause that you're finding on this?
It's in the hand paperwork that you were just holding. So, do you
What's your
understand?
probable cause? There's nothing on record, Your Honor, what you're stating as far
Mr.
as
Boyd,
probable
we're gonna
cause.
end this now, okay? I offered to have you enter not guilty pleas, now you don't wish to, so you do have to be back here tomorrow at 8:30.
Well, I object because you're practicing law from the bench and you're forbidden
I
from doing that.
understand.
It's actually 10:30.
10:30.
The only
I'm sorry.
person that can answer for me is my
Sir,
power attorney, and I don't give you
Did
consent
you
for
hear
power
that?
attorney.
You have to be back here tomorrow at 10:30. And that'll be great.
What is it?
We'd like to have a mental health assessment, so you need to be.
No, thank you, I don't consent to that, Your Honor.
In case you didn't hear that, the judge said that he wants this sovereign citizen to undergo a mental health assessment, which is understandable considering he's trying the sovereign citizen defense, which has never worked in court.
Actually, I do. It's my constitutional right. So what are you saying, is the court saying that they're gonna force me to have a mental health evaluation?
Yes, I would like you to meet with pretrial services. I'm sorry, Dave, I should.
Well, I object,
I understand.
because you don't have that power. I'm the beneficiary. Not them, not you. I'm the beneficiary of the contract of the Constitution, Your Honor.
My name is Miss Berry, and regardless, I'll walk out with you, I'll let you know my services, and we'll go from there. We'll talk outside of the
Thank
door.
you so much.
I object to anybody passing on this person without my consent, for the record. Thank you. Well, I'm sorry, I'm just standing up for my rights, and you guys are just ignoring that.
There's some more audio, but the quality of it is so terrible it's almost unhearable, so I'm not going to subject you to that. If you would like to hear the full audio, I've left a link to the source video in the description. This sovereign citizen tried the same jurisdiction argument that so many other sovereign citizens have tried in court, and once again, it failed miserably. That's gonna do it for this video. Thank you all for watching, and be sure to like, share, comment, and subscribe. And I'll see you next time.